Illegal Toronto dispensary finds legal loophole to keep doors open. Illegal cannabis purveyors in Canada continue to thrive in Canada's new legal market. Whether it's through flashy promotions, claims of delivery within hours, or prices that undercut the legal market, illegal dispensaries are doing what they can to keep their client base. That same level of brazenness is being used to keep the doors open at a popular chain of illegal Toronto dispensaries even after law enforcement and municipal enforcement took actions intended to close the stores indefinitely. A new law, in force as of October, allows authorities to close a premise if someone is charged with certain provincial cannabis offenses in relation to its address. The closure order takes effect immediately until charges are resolved by the courts, which commonly takes months. The province implemented the law to finally close down dispensaries that would open up again just hours after they were raided. That was happening earlier in 2018, and continues to happen, because search warrants themselves only authorize search and incidental arrest, and don't allow for indefinite closure. But now, Toronto's popular cafe, short for cannabis and fine edibles, seems to have found a crafty loophole to exploit. There's no place like home. Buried in the Cannabis Control Act is an exemption to the closure power. At S18(7), the Act states that the section authorizing closure orders does not apply with respect to a premise used for residential purposes. City News reports that 2 cafe outposts have been subject to closure orders after provincial charges were laid, and City of Toronto contractors welded the doors shut. Contractors later returned to unweld the doors when a lawyer for the chain claimed that an individual has been living in the basement of one of the dispensary's locations. And the shop has reopened to customers since. City News also reported that the second location of the same chain appears to be using a similar tactic following a recent raid. We spoke to a cannabis and housing lawyer, Karima Saad. She told Leafly that a court could make a determination whether the addresses are truly being used as residences, and issue an order in the meantime speaking to the sale of cannabis on the premises. Saad believes it's a complex matter that may also involve the landlord and tenant tribunal to determine if the place is a residence and thus regulated under the Residential Tenancies Act. A court of the tribunal could make this determination using a test she said is called the predominant purpose test. If someone is living there, they should get a determination if they are covered by the Act, which happens at the board. She said that law enforcement officials locking the doors complicates things and that a proper residential eviction must go through a sheriff. The City of Toronto is reportedly asking the province to look at the law and advocate for changes to the exemption provision in the Cannabis